SJC-12842, Elmer Donis and others via American Waste Services, LLC, and another.
Good morning, Mr. Cordy.
Yes, if it pleases the court, Your Honors, Robert Cordy, and with me Annabelle Rodriguez, representing the defendant appellants in this case, Mr. Carney, Mr. Galvin, and AWS. I'd like to make three related points this morning. The first is in enacting 27F, the legislature created a comprehensive and self-contained statute setting forth in detail a new right, a method for determining and setting the value of that right, and specific public and private processes for enforcing that right, including a private right of action with remedies of treble damages, interest, and attorney's fees. There is no reason to believe that the legislature did not intend this statutory scheme to cover the whole subject to which it related, and hence be exclusive with respect to that subject. Second, the private right of action provided for aggrieved employees under 27F of the prevailing wage law limits liability to their employers, and 27F was never intended to extend such liability to the individual officers or managers of those employers, such as Mr. Carney.
Could I ask about that provision? Because
sure.
I was just looking at the language itself. It says, whoever pays less than said rates shall be punished or subject to a civil violation. Why do we know that just applies to the corporate entity as opposed to the
whoever pays is the employer.
Well, okay, so that's how we...
Yeah, whoever pays, the employer pays. That's exactly right. I know the New England Legal Foundation brief focuses on that a little bit as well.
They focus they have a sentence. It should be noted that this whoever pays language refers only to the employer.
Right.
It doesn't give us a lot of substance to that analysis. I get it, but so that's obvious. And is that contested by either the other side? We'll ask them.
Yeah, we'll ask them.
Okay.
I think it is. But if you look to 27C, it means that a whole lot of people can be found in violation of 27F, including any officer, agent, superintendent, foreman, or employee, or staffing agency or works. So it's a whole lot of people
in
can be under 27C,
correct,
who could be
that's
given
basically
civil
the public
citations.
Remedy. Yes.
So but I think no one is contending that a superintendent or a foreman would be personally liable.
No.
So
not under the private right of action provisions.
So
no.
Does the whoever provision focus on 27C in terms of those individuals are the whoever's as opposed to just the employer?
I don't know the answer to that question, honestly. What I do know is that in terms of employer liability and or the liability of individuals in the employer is made even clearer by the following. Section 27 and Section 27F are the two major provisions of the prevailing wage law. Section 27 relates to a wide range of individuals who are involved in public construction works. 27F is a narrow range of operators, vehicle and machine operators, involved in public works contracts such as trash collection. Both of those sister statutes, were amended in 1993 to add the private right of action, treble damages, reasonable attorney's fees and costs. They were both amended, and the wording was exactly the same. That whoever language, by the way, I think is also in 27. In any event, in 1998, 5 years later, Section 27 and 27F were both amended. They were amended by Chapter 236 of the Acts of 1998. In Section 6 of Chapter 236, Section 27 of the law was amended to expand the definition of employer to include familiar language that's in 148, quote, the president and treasurer of a corporation and any officers or agents having the management of such corporation. So the legislature intentionally expanded individual liability under the private right of action in that amendment. Now, 2 sections later, in Chapter 236 of the Acts of 1998, the legislature amended Section 27F. But in amending Section F, it did not add this language at all. Indeed, the language about this individual liability was explicitly limited to Sections 26 through 27B and not 27F. So if ever there was a loud voice of legislative intention, the fact that they amended both statutes, same time, put language in one, creating individual liability, and declined to put language in the other, is very meaningful.
I find that significant, but I also don't understand why. Is there a reason they would do it in one place and not the other, given that we're dealing with prevailing wage laws? I mean, in the Commonwealth, and we're dealing with truck drivers versus
well, these are operators.
Right, I got it. So why would they do that?
I think that is a very good question to be addressed to the legislature.
Okay.
Indeed.
And there's nothing in the legislative history that will inform us on that?
None that I've been able to find. I mean, my guess, being very cynical, is that the number of employees and the unions that are covered by 27 were better lobbyists and made the argument, and the legislature adopted it, but declined to adopt it in 27F. The statute has been amended since then. It's never been added to 27F. So this is a limitation on liability in 27F.
If I could ask you a more global
Yes.
question. There seems to be a dispute in the opening of the briefs as far as the goal of the Wage Act. And you both focus on the detention of wages, and you focus on the timeliness of payments. But what the other side says is it's not only the timeliness, but it's the amount. You have a right to be paid on time and in full. Mm-hmm. And here we're dealing with the in full part of it. Where does at least the lower court or some of the U.S. District Court cases on overtime play into this analysis, where if someone is not paid full amount of overtime, it becomes a Wage Act violation as well?
Well, the overtime statute is somewhat different, for sure. The Crocker versus Townsend case is an interesting case on this very subject, where employees, they were viewed as independent contractors, were not paid at all for the hours they worked, and they brought a suit under the Wage Act. Not just to collect monies that they weren't paid for the hours, but to collect overtime for those hours. And the court, it was obviously brought under Section 148 of the Wage Act, which, by the way, 150 creates the private right of action, but 148 is the timeliness and the section that you were talking about. So they brought it under 148 and 150, and they said we should get overtime pay for that. And the court said, well, Under the overtime statute, you're limited because there's a statute of limitations in the overtime statute limiting your right to overtime. So although you didn't get paid for the hours worked, and therefore clearly have a 148 claim, you cannot exceed the limitations in the special statute that created the overtime right. That limitation was a statute of limitations, and therefore they could not collect the full overtime through the Wage Act. This is very similar to what we have here. Let's assume for a moment that you could bring a 27F, even though 27F has got a whole scheme with private right of action and everything. Let's assume you could bring 27F as a 148 claim, then through 150 as a private right of action. The Crocker versus Townsend analogy or analysis would say, yes, but in your 27F claim, you would be limited by the 27F limitations. So on the overtime statute piece, you're limited because there's a statute of limitations which has negated your claims under the overtime statute. Here, 27F doesn't create individual liability, so that's a limitation. So if you sought to enforce it under 148, you would be subject to that limitation. Very similar analysis. The other...
one could say that a prevailing wage essentially is a minimum wage for these workers. Do we have any case law that says that if an employer pays a wage less than the minimum wage, that constitutes a Wage Act violation? Have you ever reached that case? I've not seen it. I know that the minimum wage does not have the same provisions for treble damages as the Wage Act. So,
right. I'm not aware of it, Your Honor, one way or the other.
So if we were in fact to say that every minimum wage violation is also a Wage Act violation, you'd be in trouble.
Well, I mean, the prevailing wage where I started was this 27F is a very comprehensive statute.
Right, minimum wage
creates a very specific right. And you should know from a fact point of view, the reason the prevailing wage statute is important is because essentially half the contracts in this case, the municipalities, which are supposed to be the ones contacting the Department of Labor to get the prevailing wage schedule and standards, never did. And so there never was a prevailing wage set for half of these contracts until the contracts were already done, and indeed, were not set until the litigation began. So this whole prevailing wage thing is just a little bit different than the minimum wage thing, which is clear, set by law, it's X dollars. This depends on a whole variety of factors, and the statutory scheme sets it up and then provides a mechanism for individuals to collect treble damages if they haven't been, those statutes and their wages haven't been provided. So I think it's different than minimum wage.
Minimum wage can be complicated too, as we now know from the au pair litigation. So, so that's not always so clear.
Gotcha.
But I mean, it seems that as if we probably should treat them the same, that if we basically treat minimum wages as being done under minimum wages and Wage Act is only for the wages which are declared, we would probably want to do the same thing for the Prevailing Wage Act.
Well, again, I go back to the scheme that was set up to ensure the enforcement of the Prevailing Wage Act, very specific. Now, I will point out that what's interesting is Section 150 is the private right of action. So 148, which is the timeliness of the payment system, and timeliness of full payment, goes through 150. 150 actually enforces a whole variety of Wage Act provisions. It provides a private right of action to 11 different statutory provisions in the Wage Act, largely which don't have their own private right of actions. Of course, sections 27 and 27F are not included because they do have a private right of action and a full remedy available.
Have we interpreted others? I mean, I understand where, like the workers' comp law, where it says it's an exclusive right. Have we interpreted other statutes to provide exclusive rights? Are there some examples where they don't include that terminology, that this is your exclusive remedy? Which statute should we look at, or which cases where we do that? Are you aware of any?
I am not. There occasionally is that claim that unless the legislature says it's exclusive, then it may not be exclusive. But that can be done by implication. When a whole statutory scheme is set up.
But have we done, are there some good examples where it's done by implication that you're aware of that we can turn to? Because I'm not sure, I can't remember if you've done this in your brief or not.
It's a good question. I don't think we did do that in our brief.
Can I ask another, and this
Yes.
may be an odd factual question. You know, I take it these employees, this is their only job, meaning that they do this cleanup. They're shakers for a municipality on one contract, right? They don't have two different wages, meaning, I guess my question is like, you're driving trucks to a public construction site. You may have you may not do work exclusively for one employer. Is that an issue here, or are these people exclusively employed by one town? I'm just wondering.
Not by one town. They were exclusively employed by one company. I was not trial counsel here, and the factual record is rather long.
Right. I'm just trying to understand is there a possibility, it relates to the chief's question, that these people may have two different rates, that they may have a rate on a prevailing wage job and they may have a rate on another job, or do these people?
Right. Well, they have a salary. I mean, an hourly wage, and
right.
Presumably, if they were working, if the company was doing business with a private entity rather than a public entity, there would be no prevailing wage.
But that's what I'm asking.
Implicated.
And again, I have to look at this record, but are we going to have employees either in this under 27F or under 27 elsewhere where they have multiple wage rates?
I take it it's theoretically possible, but trash companies basically do business with municipalities, so that they don't have to do that exclusively.
And I guess my question is, could they be then enforcing under the Wage Act the non-prevailing wage part of their wages, and
Oh, sure.
and under the Prevailing Wage Act, the prevailing wage issue?
Sure. If they didn't get paid the hourly wage that they were promised.
But I'm confused though, because I assume these particular employees have only one employer
Right.
doing only prevailing wage work. That may be incorrect.
That
'cause
may
I
be
haven't read-
incorrect.
but
But what's at stake here is all the prevailing wage work.
Right, but it just raises a question whether that prevailing wage is a severable wage. The component, using the chief's analogy between minimum wage and what they get paid, prevailing wage is actually usually a plus factor, not
Right.
a, right. Okay.
Correct.
Okay, just to be clear before you leave with regard to the exclusive, I understood your brief to say that if the prevailing wage were $27 an hour and they were being paid $20 an hour.
Well, it varied between, I think, 22 and 24.
Right, put aside the numbers, I'm
Okay,
just
whatever.
saying, but if the employer says we'll pay you 20 and the prevailing wage meant that they should have been paid $27, they would still have a Wage Act violation if they failed to pay the 20 in a timely fashion.
Correct.
Okay, so you're not saying that there's no possibility of a Wage Act violation merely because they're paid prevailing wage. You're saying that it's the only way you'd get the 27 is
The extent that it is the
pursuant to the Prevailing Wage
wage
Act.
you are seeking, then the remedy is the Prevailing Wage Act. 27.
Thank you.
Thank you.
Ms. Decter.
Good morning. May it please the court. In this case, the plaintiffs, manual laborers who worked on the backs of trash trucks collecting garbage and recycling for the defendants Rentham, Medway, and Foxborough and Franklin routes, worked for many years for defendant AWS and defendants Carney and Galvin. This was hard work. It was dangerous work. And in all these years, not once, not for 1 hour, were they paid the prevailing wage that they were owed. How do we know this? We know this because the undisputed record that was assembled at summary judgment and was credited at summary judgment, and then was credited again on appeal, recognized that the laborers were not paid the minimum applicable wage they were owed for every hour they worked. Mullally establishes definitively that the prevailing wage rate is the minimum applicable wage for every hour worked on a prevailing wage job. And so we submit to you, Justices, that in this case, the Wage Act must be applied to effectuate the fullness of the plaintiff's entitlement. The issue before you here is simple. Does the Wage Act apply to workplaces which are required by law to pay the prevailing wage and yet fail to do so?
Do you know the answer to the question that has been posed as far as, and I get your argument about paid in full, timely and paid in full. But do you know the answer to the question about other situations, including overtime and or minimum wage, that may constitute also a Wage Act violation?
Yes, Your Honor. So
now, I think there's some lower court cases on overtime, if I'm not mistaken. But
there are. There's the Plord case where the appeals court ruled that comp time that was granted under the FLSA's overtime regulations for public sector.
And I'm sorry, that case again?
Plord versus City of Lawrence. It stated that the Wage Act was applicable in that case, but your own jurisprudence has decided that, for instance, with regard to the special minimum wage granted to public housing authority employees under 121B, Section 29, in the Fernandez case, that they are entitled to coverage under the Wage Act, not for whatever the defendants in that case decide to pay them, but for the full measure of what DLS ordered they were entitled to for every hour they worked. Similarly, in the Sleepy's case, you ruled that the plaintiffs were entitled to the mandatory minimum for both Sunday and holiday pay, and not just the commissions that they were owed. These are important precedents because they establish the notion that the Wage Act, they establish definitively, although I think it's obvious from the text, the Wage Act does not set a minimum rate. It does not say...
Yeah, I get that part, but
Yeah.
This is, prevailing wage is something special. And the legislature, it was a pitched battle for the prevailing wage. And this also contains treble damages, attorney's fees. Does it provide criminal liability too?
It does provide for criminal liability, but it doesn't provide for protection from misclassification. It doesn't provide for protection from special contracts.
But what, I guess the point I'm making is prevailing wage is, again, this is not an oversight area of the law. This is an area where the construction world and the labor unions battled it out, hard, and they got all these sort of explicit rights in there. And why would we think that all of that is duplicative of the Wage Act stuff, as opposed to basically this was a compromise. We're going to give you all this extra money. We're creating these rights, but we know what we're doing and we're not going any further, I guess is the question. And particularly in the light of, individual liability is a big deal. And there's also individual criminal liability under the Wage Act, right?
There is, and there also is respectfully under 27F.
Okay, so there is, so 27F provides individual criminal responsibility?
Well, yes, it does, Your Honor. In fact, the language of...
But again, and I'll stop talking, but I just want to put all the different factors in play here. So it gives you individual criminal liability, it gives you treble damages, it gives you attorney's fees. In the other 27 provision, it also provides the express individual liability. So it's a comprehensive, powerful statute protective of rights. Do we really need to have it completely duplicated by the Wage Act then?
Your Honor, we would say that it is not duplicative, it is complementary, and it's complementary in a number of ways. For one, it provides an actual wage rate. That wage rate doesn't just benefit employees, it benefits the Commonwealth.
Which provides an actual wage rate? The prevailing
27F.
Wage. Right.
27F provides the means to set a rate, just like the minimum wage and overtime statute does, just like the Sunday pay and holiday pay laws do, just like Section 29 of Chapter 121B does.
Doesn't that cut the other way then? It's so explicit. It sets the rates, it sets the remedies. It only leaves out this one thing you want, and they actually included that in the public construction world.
But it doesn't provide for timely payment. So you could have a very simple situation here. There's a guarantee that you're entitled to $24.81 an hour, but when are you going to get paid? Weekly, biweekly, monthly, semi-annually? You know, an employer could make a very easy argument that they made a deal with their employees that they would pay them at the end of a construction project, or they would pay them at the end of trash pickup. It's important to remember that.
Don't you have to set the schedule when the project begins? Isn't that part of the requirements? Don't you have to set the wage rates at the beginning of the project?
No, Your Honor, and contrary to my brother counsel's statements, this is the law of this case that the defendants were obligated to pay the prevailing wage rate whether or not a prevailing wage determination issued under 27F. That is what the law means, not just on summary judgment, but at the appeals court.
By virtue of entering into a municipal contract.
By virtue of entering into a municipal contract with a stipulation that they were obligated to pay the prevailing wage. These defendants were on notice, and these defendants signed certifications and contracts obligating them to pay the prevailing wage, and yet they failed to do so. They represented themselves as knowledgeable and experienced trash haulers, and yet they chose to defraud their workers.
But the issue is not whether there's a remedy. The issue is whether the remedy you have is under Section 27F or whether the remedy you have is also under the Wage Act. So is it your view that every prevailing wage violation is also a Wage Act violation? Or every, I should be more precise, that every failure to pay the prevailing wage, even if the wages are timely paid, is also a Wage Act violation?
Your Honor, respectfully, it is. And I'll tell you...
And is it also your view that every failure to pay minimum wage, even if timely paid, is also a violation of the Wage Act?
Yes, Your Honor, it is.
And is it your view that every violation of the Equal Pay for Women Act, for failing to pay a woman the amount that would otherwise be paid to a man, would also be a violation of the Wage Act?
That's a more complicated question because it calls into question issues of fact about whether or not it calls into lots of questions of fact. Arguably, if an individual was entitled to a higher wage that they were not paid, then it would be a Wage Act claim. But that would have to be, like with commissions.
Doesn't that run into the whole back pay issue and discrimination cases? That's a hugely complicated, whether that's really a Wage Act violation or not.
I agree with you, Your Honor. I think that that's a bridge too far. I mean, I think the way to look at this is it has to do with commission. It's like commissions.
Sorry?
It's like commissions in the Wage Act. To understand whether whether commissions are due under the Wage Act, they have to be definite and determinable, right? And you just decided the Enternock case, which relates to that. If it's sufficiently definite, then there may in fact be a claim. Otherwise, it would be hard to conceive of. The one thing I want to...
Do we have, with minimum wages, do we have case law that says that the failure to pay a minimum wage, even if timely paid, is always a Wage Act violation? I would think there would be cases that would speak to that. The minimum wage law does not provide for a civil remedy.
Well, Your Honor, respectfully, the Wage Act has been interpreted by both this court and the appeals court to protect the highest guaranteed wage to an employee, whether it's an extremely highly compensated individual or the most lowly compensated individual. It doesn't guarantee what an employer wants to pay. It guarantees what they're required to pay. And the reason we know this is because of the special contracts provision. The special contracts provision of Section 148 creates a non-delegable right to the employee that their wages cannot be, their right to wages cannot be limited by an employer's exploitation or superior power. We would submit to you that the minimum wage rate has to be the very least that an employee gets under the Wage Act.
No question. Okay, well, no question that that's what they're supposed to pay, but the minimum wage law only provides civil remedies for somebody who knowingly pays or agrees to pay to any employee less than the rates applicable. So we have a minimum wage law which is limited to a knowing violation for a civil citation, and you would be saying, well, actually every minimum wage law violation is also a Wage Act violation, which is a strict liability violation, which also is a criminal violation based on strict liability. I mean, isn't there a problem when we begin to characterize, when we begin to say minimum wages, prevailing wages are now all Wage Act violations, given that they're crimes, or that they're strict liability crimes?
Your Honor, frankly, we're here on a civil matter here, and so...
I understand, but your basic principle is that, I mean, your brother is basically saying we should view the Wage Act to essentially say the employer says he'll pay X to the employee. If the employer fails to pay X in a timely fashion, that's a Wage Act violation. Mm-hmm. You're saying no, you're saying yes, certainly the failure to pay X is a Wage Act violation, but where the prevailing wage says he should pay X plus Y, or where the minimum wage law says he or she must pay X plus Z, that the failure to even the timely payment of X does not suffice, and that the failure to pay X plus Y or X plus Z by itself is also a Wage Act violation.
Your Honor, what we would say to you is that the Wage Act provides for the full and timely payment of wages. Full has been interpreted by this court to include contract claims of hundreds of thousands of dollars. See the Enternock case. Full means full, and full has to mean at least the statutory minimum. Otherwise, there is a constant race to the bottom. I'd like to go back to...
Before you do, I just want to make sure you address you have a simple way of winning if you're right, which is whoever pays. Can I understand your interpretation of what whoever pays? And also, you made some kind of comment that I'm not sure I fully followed about they signed some personal documents. Did these individuals make some kind of personal representation when they got those contracts? So could you answer those two questions, please?
Yes, I can. So what's interesting about the whoever clause of the of 27F is that it is extremely expansive. Whoever pays less than said rates of wages on said works, and whoever accepts for his own use or the use of any other person as a rebate, gratuity, or in any other guise, any part or portion of said wages, health, or welfare funds shall have violated this section. That is not just a violation of criminal law or of civil law, which 27C is both criminal and civil, but it is a violation of the section. Whoever, we are told by Chapter 4, Section 7 of the General Laws, and the term person as used in 148 are analogous. They mean the same thing. Any person having employees in their service is used in Section 148. Whoever fails to pay is used in 27F. What we would say to you is that while 27F does not say by virtue of a individual holding a title of president or treasurer, they are held liable under the prevailing wage law, that doesn't mean that by their actions they cannot be held liable as a matter of law under 27F.
But how do they pay? I mean, whoever pays, right?
Yes.
So how does, make that language work for you so that I can understand how that works for you?
Okay, so in this case, defendants Galvin and Carney were the co-owners and sole managers. They ran the company, and all benefit of these contracts inured to them. And so...
But they didn't make the payments themselves,
But
right?
the court found that they supervised these contracts and that they supervised individuals who were responsible for paying these individuals. And certainly, whoever pays less than said rates of wages and whoever accepts for his own use should include co-owners and managers who are responsible for the supervision.
The second part of that phrase, whoever accepts for his own use, so if they didn't pay, if the company didn't pay the full amount and these guys got the profits from that, they fit within the second part of this clause?
Certainly where well, yes, I think that's a fair literal reading of this, but I think beyond, and I think this is very specific to the purpose of trying to end kickbacks in municipal contracting, which is what this law was.
We don't have a kickback here, and there's nothing in this record indicating anyone got a kickback, so.
In any case, I think that the import here is that whoever is a very broad term. The legislature has said so very explicitly in Chapter 4, Section 7, and whoever should include both those who directly supervise and those who get a direct benefit from the rebate, gratuities, or any part or portion of wages or health benefits that are withheld. With regard to your other question, in our record appendix, volume 2, you will see that there are a number of contracts and certifications that the defendants signed individually, which include certifications of their obligation to pay prevailing wage. These individuals were well aware of their obligations. They held themselves out as responsible prevailing wage contractors to the companies or to the communities that they served, and these communities failed to see the benefit of that.
Where is that? Just, do you know off the top of your head where in the record that is?
One moment.
Or you can keep talking and have her give you this thing.
Yeah. Thank you.
Before you leave that, the whoever provision in 27F goes on to say, shall have violated this section and shall be punished or shall be subject to a civil citation or order as provided in section 27C. And 27C certainly includes the president or treasurer, but it also includes any officer, agent, superintendent, foreman, or employee, but it doesn't provide for civil liability. It provides for civil penalties or punishment by a fine or for imprisonment.
Your Honor, that's a fair point, but what we will say to you here is that what's important to note from this is that there's only one phrase for what a violation of this law constitutes. This law nonetheless allows a private right of action. It cannot be that only a corporate defendant is liable here. If it was an individual proprietor, they would have liability. If it was a partnership, they'd have liability. If it was an agent of an unincorporated association, they'd have liability. And there is one case that I'll cite to you from the Superior Court that makes this point quite well. It's called Nikorowski versus Mathai. It is civil action number 11-4315-BLS1. The Westlaw citation is 2012 Westlaw 5309524 at page 6. And in that case, what the court says is that just because an LLC manager can't be held individually liable by virtue of his title, that doesn't mean that he can't be held liable for actions in tort or contract. That when he takes actions in his official capacity, but illegal actions, that he can be held liable civilly. And we would submit to you that that's the same, and respectfully, that is the import of the Cook case, and what speaks.
But the Cook case was interpreting the language that is not present in 27F, but is present in 27.
Correct. But what we would say is that whoever is an exceptionally broad term, and whoever has to apply to more than just a corporate defendant.
What is what was the purpose then for the legislature to include the language that it added to section 27, but limited to sections 26 through 27B?
Your Honor, the legislative history is silent. And so we're never going to know the actual reason. But I think what's really relevant here is that the Wage Act was amended in 1935 to specifically include liability for corporate officers by virtue of their title. It wasn't till 1993 that either the Wage Act or the Prevailing Wage Act was moved from what's now DLS to the AG's office, and the private right of action was granted for either statute. There are many possible explanations. The most likely one is that the omission was incidental. Contrary to my brother counsel's comments, 27 and 27F are not the primary sections of the Prevailing Wage Act. There are Prevailing Wage Acts. There are other sections that also define prevailing wage for other types of workers. 27G deals with bus drivers. 27H deals with maintenance workers and janitors. The 27F, G, and H are small industry prevailing wage acts. They are not unlike the Prevailing Wage Act provided for in 121B, Section 29.
So the big construction projects,
yeah,
they're all protected, but these little guys aren't, right? bear with me, let me finish the question. Is that maybe a reflection of just raw political power, and that we gotta recognize that? I mean, it may not be fair, and if you lose, I'm sure the legislature will get a second shot at this, but is this right that, I mean, you think about those giant construction projects, they're all covered, right?
That's right.
Just these smaller guys, somehow the legislature didn't expressly weigh in.
I think that's right, Your Honor. I think that we're in a situation now where we can't know why the legislature was silent with regard to 27F. But this court generally has not read exclusivity in where it is not explicit in the law. And while, yes, 27F provides a private right of action, there are many components of wage protections that it does not provide. It doesn't provide record keeping. It doesn't provide it doesn't provide anti-retaliation. It doesn't provide protections against deductions. All of those things are covered by the Wage Act. So that's of real import.
Okay. I think your time is well over. So, but it's not your fault. We ask questions, but I think we will end this and we will take our morning break.
Thank you.